You're watching The Business of Law, brought to you by Bloomberg Law and the ABA Journal. I'm Lee Pacchia. We've spent a lot of time on this show looking at the fallout from the recession in big law, the layoffs, the reductions in compensation, and law firm closures. My guest today is going to help us take a look at the underlying causes of disruption in the legal profession and talk about some of the ways law firms can negotiate this period of change. We're joined now by Trevor Faure, global leader and partner in the legal services group at Ernst Young. Welcome back to the program.
Good
to see
you.
This is a tough time for all of professional services, but law seems to be having a particularly tough go of things. Why is that?
Well, you'd think watching the channel, in fact, from your introduction, that the legal profession was undergoing strangulation. Whereas, in fact, it's, I'd say, more a process of a triangulation, whereby the traditional deliverables of the law firm or legal practice, in-house or otherwise, are coverage, the output of legal product. High levels of coverage lead to high levels of compliance, the second output, and hopefully done in a way that drives high levels of client satisfaction. And that's at the peak of the triangle, as it were. But at the other 2 points are the things that are most under pressure today, namely the talent headcount point.
Law firms have too many employees.
Well, in-house or law firms, headcount's always a pressure point. And also the cost, the net cost of the entire service. Internal lawyers, external lawyers, and the cost of failure, the cost of not having adequate coverage, adequate compliance, and which in fact distorts the overall cost triangle. So in the current crisis, you have the more for less pressure, the perfect storm. More coverage, more compliance due to higher regulation, always a need for higher client satisfaction, but with less headcount and less net cost.
So you had this really interesting article in the Lawyer magazine recently where you referenced a survey showing that law firms view their highest priorities for improvement in the areas of people management and process efficiency. Why is that?
Well, that's very encouraging. I think it is a response to that perfect storm. What we apply with the smarter legal model is a Six Sigma type approach, whereby it's basically common sense with metrics, defining, measuring, analyzing, and improving any product, any project. It could be your grocery shopping, but basically complex areas such as law can go through the same process. Now, law firms, in response, modernizing to those imperatives, are going through that very same process, as are the in-house departments.
Now, to fix operations in these two areas, what are the top things law firms should be thinking about doing?
Well, you know, here's the thing, Lee. I think it's very important that we recognize that the issues are the same, both in-house and external. It's very important. And there are three, you know, in the application of, for example, the smarter legal model, it throws up three very current developments that are very positive, but do involve change. One is addressing the zero-sum game relationship between law firms and clients. That, for me to win, you've got to lose. I can talk about that. Secondly, disaggregating the overall workload, whether it's one project such as a major acquisition or the entire workload of a law firm or an in-house department, separating the cream from the commodity, as it were. And thirdly, the use of technology, big data analytics, that in fact not only just provide more for less, but actually better quality for less.
Some of the things that we've talked about today, it seems that the accounting firms out there, particularly the Big Four, seem to get them so right. Legal service providers don't. Why is that? Are we talking about a cultural difference here between the two professions, or is there something else at play?
There is one interesting aspect that I've been on many sides of in terms of that's quite unusual to law firm client relationship, and that's what I described earlier as zero-sum game behavior. It's part of, you know, analysis of it's called Pareto optimal behavioral economic analysis. But basically put, between you and I, law firm and client, for me to win, you've got to lose. And you can see examples of that, Lee, even in the legal profession, where, for example, there are software packages that are, you know, reasonably and sensibly offered, allowing the client to see patterns of overcharging from the law firm. Well, here's the thing. If your best friend said to you, look, I'm using this software package to ascertain whether my partner is cheating on me, you should use the same, Lee. You would not tend to say, I'll use it. You'd say, you, my friend, are in the wrong relationship.
Right.
But in law, we take it almost as an acceptable level of mistrust. That, well, you may be overcharging me, I'm going to look. And by the way, as a client, I'm going to ask for unreasonably low rates that are unsustainable and unprofitable for you, and we're just going to hash it out. It's the net sum is zero. If I may, by contrast, and this is where the better examples are, you have law firms that are following the smarter pattern of incentive schemes that are based on the real interests and needs of the company as well as the law firm. Just one example. Any law firm that has a critical mass of work from a client, let's say 100 of anything, litigation cases 200, any statistically significant amount, can do one of two things. It can hope that another 100 or 200 of those occur next year, so that I can keep billing and put my children through school, or...
Which is a tough business model.
But it's a traditional one. You have 200 problems this year, I hope you have another 200, and I continue to bill. Or I can take the data that I currently have about your behavior, your company, your litigation space, and identify the main groups of fault, root cause analysis, and advise you how to avoid them in the forthcoming year, in return for which you will pay a significant bonus if that advice works. So in that sense, you can do it mathematically, and I've put these schemes in place with leading law firms. The client, actually even paying the bonus, pays less net because it's not paying for the legal expense of the 200 cases the next year and the fallout in terms of loss management time. It's not to say that cases are actually eliminated or settled, that's a different subject, but by using the information that the law firm already has on the client in terms of its worst behaviors, it can proactively advise for it to avoid its repeated behavior next year in return for a significant bonus.
We're 5 years on into a significant recession for big law. At this point, are you seeing improvement in any areas? Are you starting to become confident that law firms are actually going to be able to employ the advice you're giving out today?
Well, I'm in the honoured position to be able to speak to many, and many are, I'm pleased to say, key in terms of in the key areas in terms of process improvement and disaggregating work, and now the use of technology and analytics. But the bottom line of it for law firms as well as general counsel, I would say, Lee, is this: change as an imperative will be done by us, or alternatively to us.
Yikes. Trevor, thank you for
Good
stopping by.
to see you, Lee. Nice to see where you live, by the way.
Right on, yeah. This is my
around.
home. I sleep over in the corner over there.
Continuously, it seems.
Thanks for stopping by.
Good to see you.
That's Trevor Faure from Ernst Young. If you'd like to learn more about the issues we just discussed, be sure to go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates, of course, on Twitter. I'm Lee Pacchia. Thanks for watching.